Welcome to Supreme Court Opinions. In this episode, you'll hear the Court's opinion in CC/Devas, Mauritius, Limited v. Antrix Corporation. In this case, the Court considered this issue. Must plaintiffs prove minimum contacts before federal courts may assert personal jurisdiction over foreign states sued under the Foreign Sovereign Immunities Act? The case was decided on June 5, 2025. The Supreme Court ruled that the FSIA itself provides the sole basis for asserting personal jurisdiction over foreign states and their instrumentalities, without the need to establish minimum contacts under the Fifth Amendment's Due Process Clause. The Court emphasized that the FSIA's provisions govern the extent to which foreign states can be sued in U.S. courts, and that the statute's specific rules supersede general constitutional principles regarding personal jurisdiction. This decision clarifies that when a foreign state or its agency is subject to suit under the FSIA, the standard for personal jurisdiction is determined by the FSIA's provisions, not by the constitutional minimum contacts test typically applied in domestic cases. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the Court. Under the Foreign Sovereign Immunities Act of 1976, FSIA, 28 U.S.C. Sections 1330, 1602 et seq., foreign states are generally immune from suit in United States courts, but the Act creates several exceptions. And when an exception applies, Section 1330A of the FSIA vests federal courts with original jurisdiction over such claims. This suit concerns the FSIA's neighboring personal jurisdiction provision. It provides that personal jurisdiction over a foreign state shall exist whenever 1. An exception to foreign sovereign immunity applies, and 2. The foreign defendant has been properly served, Section 1330B. In the decision below, however, the Ninth Circuit imposed a third requirement. A plaintiff must also prove that the foreign state has made minimum contacts with the United States sufficient to satisfy the jurisdictional test set forth in International Shoe Company v. Washington. Because the Ninth Circuit's additional requirement goes beyond the text of the FSIA, we reverse. Like so many disputes, this one began with two companies and a contract. Antrix Corporation Limited, Antrix, is organized under Indian law and is owned by the Republic of India for use by its Department of Space. In Antrix's words, it serves as the commercial arm of Indian Space Research Organization, a division within the Department of Space, and is tasked with promoting and commercially marketing the products and services emanating from the Indian space program. The Indian government finances most of Antrix's operations and appoints much of its leadership. In January 2005, Antrix signed a satellite leasing agreement with Devas Multimedia Private Limited, Devas, a privately owned Indian company incorporated to develop satellite-based telecommunications technology. Under the agreement, Antrix would build and launch a new satellite network into geostationary orbit, specifically, at the 83 degrees east orbital slot, and lease some of that network's capacity back to Devas. Devas, in turn, would use its leased satellite capacity to provide multimedia broadcasting services across India. The agreement proceeded as expected for several years. Antrix obtained project approval from the Indian government and clearance from the International Telecommunications Union, the arm of the United Nations responsible for allocating orbital satellite space among member states. For its part, Devas secured the requisite internet and television provider licenses, brought on investors, and paid Antrix the contractually required fees. And as satellite construction neared completion, the parties performed several successful trials of Devas' newly developed software and infrastructure. In February 2011, however, Antrix and Devas hit a snag. Just before the satellites were scheduled for launch, the Indian government determined it needed greater satellite capacity for itself and could no longer lease its limited S-band spectrum, the type Antrix and Devas planned to use, for commercial use. So, at the behest of government officials, Antrix terminated the agreement with Devas. Citing the contract's force majeure clause, Antrix explained that India's new satellite allocation policy prevented it from continuing performance on the contract. But Devas thought Antrix was liable for the financial fallout. So Devas invoked the contract's arbitration provision, commenced proceedings, and argued the purported force majeure was self-induced. The three-member arbitral panel ruled unanimously for Devas on September 14, 2015. Applying Indian law, the panel concluded Antrix had wrongfully terminated the contract and awarded Devas $562.5 million in damages plus interest. After successfully confirming the arbitration award in France and the United Kingdom, Devas sought to do the same in the United States. In 2J Grenig, Dom C on commercial arbitration, we noted that confirmation of an arbitration award finalizes the award and makes the award a judgment of the court. In September 2018, Devas petitioned the United States District Court for the Western District of Washington to confirm the award, citing the FSIA's so-called arbitration exception as the basis for federal jurisdiction. Antrix moved to dismiss, arguing, inter alia, that the district court lacked jurisdiction. For much of American history, foreign states and their instrumentalities enjoyed near total immunity from suit in our courts. In Hungary v. Simon, we noted that this posture reflected the venerable international law principle that states are independent sovereign entities, and it encouraged others to respect the sovereignty of the United States in their courts. In Bolivarian Republic of Venezuela v. Helmerich and Payne International Drilling Company, we recognized that this immunity was not statutorily or constitutionally required. Instead, in Republic of Austria v. Altman, we have long understood foreign sovereign immunity as a matter of grace and comity, so judges historically deferred to the decisions of the political branches, in particular, those of the executive branch, on whether to take jurisdiction over particular actions against sovereigns and their instrumentalities. In practice, that usually entailed the State Department filing a case-specific suggestion of immunity whenever a foreign sovereign was sued, and when that occurred, the court would abide by the suggestion, as discussed in Samantar v. Youssef. Beginning in the mid-20th century, the executive branch adopted a more nuanced stance towards sovereign immunity, but its new approach proved troublesome, as noted in Verlinden. Specifically, the State Department declared in 1952 it would no longer suggest immunity in cases arising out of a foreign state's strictly commercial acts. While this shift brought the United States into parity with the emerging international consensus, it also provoked tension and confusion. Foreign nations often placed diplomatic pressure on the State Department, and, on occasion, political considerations led to suggestions of immunity in cases where immunity would not have been available. Furthermore, in instances where the State Department simply failed to file any suggestion, courts were forced to determine immunity based on standards that were neither clear nor uniformly applied. Congress addressed the problem in 1976 by enacting the FSIA, now the sole basis for obtaining jurisdiction over a foreign state in our courts, as stated in Argentine Republic v. Amarada Hess Shipping Corporation. Instead of case-by-case determinations that were governed by fuzzy legal standards and prone to manipulation, the FSIA imposes a bright-line rule. Foreign states and their instrumentalities are immune from suit unless one of the Act's enumerated exceptions applies. Exceptions include claims based on commercial activities with a specified nexus to the United States, claims based on torts that have caused domestic personal injury or property damage, claims based on certain expropriations, and several others. The Act also waives immunity for suits to confirm arbitration awards. The arbitration exception applies in 4 statutorily defined contexts, including where the agreement or award is governed by a treaty or other international agreement in force for the United States calling for the recognition and enforcement of arbitral awards. The United States, for instance, has acceded to the New York Convention, which requires it to enforce certain awards issued abroad. In such instances, and when the FSIA is otherwise satisfied, the arbitration exception would also apply. Whenever an FSIA immunity exception applies, jurisdiction usually follows. That is because the Act's jurisdictional provision, 28 U.S.C. Section 1330, pegs both subject matter and personal jurisdiction to the exceptions. Subsection A of that provision grants district courts original jurisdiction over any claim for relief in personam with respect to which the foreign state is not entitled to immunity, under Sections 1605 to 1607, which are the FSIA immunity exceptions. And subsection B provides for personal jurisdiction as to every claim for relief over which the district courts have jurisdiction under subsection A. I.E. for every claim subject to an immunity exception, and where service has been made under Section 1608. In Republic of Sudan v. Harrison, we discussed Section 16.8 Specialized Service of Process Rules. Once this dispute arrived in federal court in this country, a dramatic series of events unfolded. Upon satisfying itself that jurisdiction was proper under the FSIA's arbitration exception, the district court confirmed the award and entered a $1.29 billion judgment against Antrix. Yet before Devas could collect, an Indian corporate law tribunal found that Devas, an Indian company, had procured the Devas-Antrix agreement by fraud, so the tribunal appointed an Indian government official to seize control of Devas and wind down its affairs. Quickly thereafter, several Devas shareholders and an American subsidiary attempted to intervene in the federal proceedings below and to enforce the judgment themselves. Successfully so, over Devas's and Antrix's objections, they intervened, secured post-judgment discovery to locate Antrix's domestic assets, and registered the judgment in the Eastern District of Virginia, where Antrix held executable assets. Then, adding one last wrinkle to an already complex dispute, the High Court of New Delhi set aside the arbitration award based largely on the Indian Corporate Law Tribunal's earlier fraud determination. Several appeals followed, and a Ninth Circuit panel found that personal jurisdiction was lacking and therefore reversed the district court's orders confirming and registering the award. The court did not question that for purposes of the FSIA, Antrix is a foreign state, service has been made, and an enumerated exception applies. Yet bound by circuit precedent, the panel explained that the Act imposes an additional requirement. Personal jurisdiction under the FSIA also requires a traditional minimum contacts analysis, a reference to our jurisdictional due process test first developed in International Shoe Company v. Washington. In Walden v. Fiore, we elaborated on this standard. Applying that standard, the court concluded that Antrix lacks sufficient suit-related contacts with the United States and that the lawsuit must therefore be dismissed. We granted certiorari to decide whether the FSIA requires proof of minimum contacts before a court can exercise personal jurisdiction over a foreign state. We hold it does not. The facts of this suit are complex, but the legal question we address today is straightforward. The text and structure of the FSIA demonstrate that Congress did not require minimum contacts over and above the contacts already required by the Act's enumerated exceptions to foreign sovereign immunity. We start, as always, with the relevant statutory text. Here, that is the FSIA's personal jurisdiction provision, 28 U.S.C. Section 1330b. It provides, personal jurisdiction over a foreign state shall exist as to every claim for relief over which the district courts have subject matter jurisdiction under subsection A, where service has been made under Section 1608 of this title. As noted earlier, this provision imposes two substantive requirements, one related to subject matter jurisdiction, the other related to service of process. First, district courts have subject matter jurisdiction under subsection A, when any of the VAS immunity exceptions applies. In Amerata Hess, we clarified this requirement. Second, service has been made under Section 1608 when a plaintiff complies with the FSIA's specialized service of process rules. In Harrison, we discussed these rules. When both criteria are satisfied, the statute declares that personal jurisdiction shall exist, and, as in other contexts, the use of the word shall creates an obligation impervious to judicial discretion, as noted in Smith v. Spiteri. Thus, the most natural reading of Section 1330b is that personal jurisdiction over a foreign sovereign is automatic whenever 1. An exception to immunity applies, and 2. Service of process has been accomplished, as stated in Samantar. In Verlinden, we affirmed this interpretation. Or phrased in even simpler terms, subject matter jurisdiction plus service of process equals personal jurisdiction, as observed in GSS Group Limited v. National Port Auth. Notably absent from Section 1330b is any reference to minimum contacts. And we declined to add in what Congress left out. The FSIA was supposed to clarify the governing standards, not hide the ball. In Verlinden, we noted this purpose. Although nothing in the text of Section 1330b requires a minimum contacts analysis, that does not mean Congress dispensed altogether with proof of contact between the foreign state and the United States. In order for subject matter jurisdiction to exist under the FSIA, an exception to immunity must apply. And the FSIA's immunity exceptions themselves require varying degrees of suit-related domestic contact before a case may proceed. Some exceptions call for considerable domestic nexus, such as rights in immovable property situated in the United States, commercial activity carried on in the United States by the foreign state, or commercial activity of the foreign state elsewhere that causes a direct effect in the United States. In Verlinden, we discussed these requirements. Others, like Section 1605A's terrorism exception, are satisfied by less direct or pervasive contact with the territory of the United States, as the parties acknowledge. To the extent that some or all FSIA exceptions satisfy international shoe, it is only because the exceptions Congress wrote happen to meet that standard, not because Section 1330b secretly incorporated our jurisdictional due process cases. The Act structure reinforces this straightforward reading of Section 1330b's text. In Republic of Argentina v. NML Capital, Limited, we recognize that the FSIA comprehensively regulates the amenability of foreign nations to suit in the United States, quoting Verlinden. The Act's immunity and jurisdictional provisions are the foundation of this comprehensive scheme, and Congress deliberately tied them together. Namely, whenever a Section 1605 to 1607 exception applies, Section 1604's immunity falls away, and Section 1330 grants jurisdiction. In Amerata Hess, we detailed how immunity and jurisdiction work in tandem. In Verlinden, we reiterated this point. In Price v. Socialist People's Libyan Arab Jamahiriya, it was observed that the FSIA collapses subject matter jurisdiction, in personam jurisdiction, and sovereign immunity into a single inquiry. And, in the narrow instances where Congress did not want for immunity and jurisdiction to be coextensive with the enumerated exceptions, it said so. Instead of enforcing these provisions as written, the Ninth Circuit read an additional requirement into one, and only one, of the FSIA's tethered immunity and jurisdictional provisions. As a practical matter, That would weaken the link Congress forged among foreign sovereign immunity, subject matter jurisdiction, personal jurisdiction, and the enumerated exceptions. It would also create a gap in the Act's otherwise comprehensive framework. In Altman, we noted this framework. In JAMA v. Immigration and Customs Enforcement, we stated that we do not lightly assume that Congress has omitted from its adopted text requirements that it nonetheless intends to apply. And we are all the more reluctant to do so where, as here, reading such a requirement into the statute would upset the carefully calibrated system Congress chose. In Turkiya Hulk Bankası ASV United States, we emphasize this point. The Ninth Circuit based its contrary interpretation on a strange statutory argument and on the FSIA's legislative history. Neither overrides Section 1330B's plain meaning. As noted by the court below, the Ninth Circuit first read Section 1330B to require satisfaction of the traditional minimum contact standard in an earlier precedent, Thomas P. Gonzalez Corporation v. Consejo Nacional de Producción de Costa Rica. Gonzalez offered two pieces of support for that conclusion. First, one of the enumerated immunity exceptions requires proof of a direct effect in the United States, which Gonzalez interpreted as embodying the minimum contact standard of international SHU. In Rote v. Zell Custom Manufacturing LLC, it was clarified that the direct effect requirement does not incorporate the minimum contacts test. Second, Gonzalez then read the legislative history of the Act, particularly the House Judiciary Committee report's discussion of personal jurisdiction, to confirm that the reach of Section 1330B does not extend beyond the limits set by the international SHU line of cases. In Epic Systems Corporation v. Lewis, we noted that legislative history is not the law. Even accepting Gonzalez's cited authority on its own terms, we do not find either step of the Ninth Circuit's analysis compelling. The fact that one of the immunity exceptions contains language resembling the minimum contacts test says little about whether a jurisdictional provision located elsewhere categorically imposes that test. Each immunity exception should be interpreted according to the text Congress enacted, as we clarified in Simon, and so should Section 1330B. To the extent it is relevant, the legislative history Gonzalez cites is not to the contrary. True, the House report says, the requirements of minimum jurisdictional contacts and adequate notice are embodied in the personal jurisdiction provision. But then the report explains that this embodiment of due process comes from the Act's immunity exceptions and service of process rules, not a minimum contacts requirement silently emanating from Section 1330B. Each of the immunity provisions in the bill, Sections 1605 to 1607, requires some connection between the lawsuit and the United States, and, the report notes, Section 1330B's plain text incorporates these jurisdictional contacts by reference. The report then makes the critical point. These immunity provisions therefore prescribe the necessary contacts which must exist before our courts can exercise personal jurisdiction. Section 1330B also satisfies the due process requirement of adequate notice by prescribing that proper service be made under Section 1608 of the bill. In Rote, it was noted that the House report shows only that Congress believed that the contacts set forth in the immunity provisions satisfy due process requirements. It is a separate question whether Congress was correct in its assumption. Thus, the VIA's legislative history leads to the same result as Section 1330A's text. Personal jurisdiction rises and falls based on whether an immunity exception applies and the plaintiff has effectuated proper service. Antrix does not defend the Ninth Circuit's reasoning. Instead, it raises various alternative reasons why we should affirm the decision below notwithstanding its misreading of the FSIA. Namely, Antrix contends that the Fifth Amendment's due process clause itself requires a showing of minimum contacts before a federal court can exercise personal jurisdiction over a company owned by a foreign sovereign. Antrix also argues that the claims at issue in this dispute do not fall within the VIA's arbitration exception, properly conceived, and that the suit should be dismissed under forum non-conveniens. We decline to answer those questions today. The Ninth Circuit relied exclusively on its interpretation of the FSIA's personal jurisdiction provision, so that court has not yet addressed Antrix's alternative arguments. In F. Hoffman La Roche Limited v. Impegrin S.A., we stated that, and, for that reason, neither shall we. In United States v. Oakland Cannabis Buyers Cooperative, we affirmed this principle. Of course, Antrix is welcome to litigate these contentions on remand consistent with principles of forfeiture and waiver. Personal jurisdiction exists under Section 1330B of the VSHA when an immunity exception applies and service is proper. Because the Ninth Circuit required more, we reverse the judgment below and remand the suit for further proceedings consistent with this opinion. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.